Good to go, Kathy.
Okay, thank you. Well, good evening, everyone. This is the February 16th, 2021 meeting of the Common Council's Planning, Land Use, and Economic Development Committee. Committee members present, Councilmember Judy Doche, Councilmember Tom Hoey from the committee. Other council members are Councilmember Richard Conti. Council staff, Michelle Andre and John Raphael Pichardo. And we have city staff, Aaron Glennon from the Planning Department, Brad Glass, Director of Planning. We have Director of Buildings, Rick LaJoy, and Valerie, I'm forgetting your title. Valerie Scott, welcome. And we also have John Myers from the Historic Resource Commission. Thanks for coming, John. And I should also mention Alfredo Ballerin, who is a committee member also. Councilmember Ballerin is here. Welcome, everyone. Aaron, did I get you? Yes, I did. Okay. We're here tonight. We've got another pretty big agenda. We're going to start by discussing Local Law M of 2020, sponsored by Councilmember Conti, lead sponsor. Local law amending Part 4 of Historic Resources Commission of Article 12 of Chapter 42 of the Code of the City of Albany in relation to appointments to the Historic Resource Commission and the jurisdiction of such body to review emergency actions within historic resources overlay districts, and further providing for a report on emergency demolition and stabilization procedures. We will then be discussing Ordinance 2192-20. That's also sponsored by Richard Conti, an ordinance amending building Article 9, which is building construction regulation, and Article 11A, which is the vacant building registry of Part 2, building construction, of Chapter 133, building construction of the Code of the City of Albany in relation to emergency building actions in historic districts. And then we will turn to Ordinance 46-122-20, which is an ordinance amending Chapter 375, the Unified Sustainable Development Ordinance of the Code of the City of Albany by renumbering such chapter. Okay, so I know, Richard, why don't we start with you and just give us a very brief update of why you brought this legislation forth and where we're at here.
Yeah, so let me just recap some things, and I'll note that this was discussed at the HRC meeting of February 3rd and also a previous HRC meeting. I've listened to both and to the discussion by members and staff at those meetings. And I think there was some confusion or some lack of clarity as to what the intent was. The overall intent is just to establish the HRC's role to some extent in oversight of emergency actions and help in development of or give them the authority to make recommendations on policy. But let me quickly, and the local law and the ordinance go together, even though they're separate proposals, just because of the way the code is structured. One has to be done by local law, one by ordinance. So let me quickly review and to try to clarify some points. On the local law, the first section deals with a time frame for appointments to the commission, which is a long-standing discussion we've had generally on the council about the timeliness of the submission of appointments subject to confirmation. And that part doesn't deal directly with the emergency action issues. And I'm thinking I might just take that entire section out and deal with it in a different proposal because it is a broader issue than the HRC section. But let me go down to section 2 on the local law. Section 2 amends the section of the code that deals with the power and authority or responsibilities of the HRC, where there's a long listing, the HRC shall have this authority, shall do this, do that, etc. The intent here is to establish their authority to have oversight or review of emergency actions within an historic district. And also to provide them the authority to periodically, from time to time, make recommendations as they see fit to the council and to the mayor, and that it be, a standing item on the agenda. We have bodies ordinarily have an agenda form that they follow through. Sometimes there is nothing on that agenda section, so it wouldn't be discussed. But this is separate and distinct from Section 3 of the local law. And I think there was some confusion or maybe lack of clarity in the HRC discussions that I heard about the difference between Section 2 and Section 3. They're separate and distinct from each other. Section 2, the amendment to subsection B, is meant to give the HRC ongoing general oversight. Section 3 is an unconsolidated amendment or unconsolidated section of local law. It's not an amendment to the city code. It's a standalone provision that just requires that the HRC do a one-time report to the council regarding policy and procedures related to emergency actions, and to make such recommendations as they see fit to the council. That was just supposed to be a one-time report, kind of an overarching, you might say, foundational report for them to take a comprehensive look at policies and procedures if they wished, and then to make a report to the council. It's separate from the amendment in Section 2 of the local law. So they are separate issues, and they're not contradictory. They're, you might say, complementary. And that's what's in the local law. Some of the information that would be provided to the HRC that would give them greater authority to review emergency actions, that's in the ordinance. And the ordinance, again, to clarify, there is some general language here about standards for emergency action, but the meat of it is intended to provide to the HRC from the buildings department information as to when an emergency action takes place in an historic district, so that they receive notification and that they receive the information that is the basis of that emergency action. So in the ordinance, my proposal had included that they be, when an emergency action is determined, that the HRC shall immediately be notified, and that they would receive, it would include the transmittal of any structural or engineering reports and the commissioner's finding and considerations that are the basis of that action. So that is intended to provide the HRC the information that's complementary to the oversight authority that's granted in the local law. And then it also amends the section dealing with the vacant building registry reports, just to include in there information that relates to the number of vacant building registrations and actions within historic districts, and to break that down. And I'll note that on January 7th, the council did receive the January quarterly report. I'm always trying to figure out which way best to hold these things so that the camera catches it. I'll say, Rick, in terms of the report that he provided, actually included the information that I had proposed to be included via the ordinance amendment under the ordinance. And that was a breakout of registrations in historic districts by individual historic district, the total number of the amount that had been and the amount that had been subject to. I don't know, do you have it here, Rick? The total properties known to be vacant by historic district, the number of registrations newly filed, the total registered vacant properties, and the percent known to be vacant. The one thing that doesn't include, I think, is if to the extent that there may have been an emergency action in any of those districts. But basically, the report that we received for January pretty much encompasses what the ordinance would look for. And this is the vacant building registry really is, there used to be a time when it actually had information as to actual properties and listing of properties, et cetera. I know we eliminated that a while back because of a concern that it almost provided a roadmap for people who were looking for vacant properties. It is what it is, but so the vacant building registry report is really just a statistical report now that gives you numbers, and it provides that, I'm trying to make it more useful as far as what the impacts or the breakouts are in historic districts. So that was the intent. And then we did get earlier today, which we'd gotten a little bit earlier, a memo from Amy in Corp Counsel's office reflecting, I think, the discussion at the last HRC meeting and recommendations for revisions from based on the HRD discussion and from planning staff. I don't know if everybody got that. Michelle did sound it out earlier today. And I don't know if anyone did not get that as far as members of the committee.
No, yeah, we did. It was sent out to everyone, all council members, by Michelle.
Yes.
So my question would be about that, Richard, is there's just, Amy's made quite a few different recommendations here, and
yeah,
it's important that you have an opportunity to go through those. I don't think we have.
So
I looked at it briefly, but
yeah, I did go through. I mean, and it does. It outlines, and maybe you want to turn it over to Amy at some point, but it does outline some of their observations and recommendations, and it also does include attachments that are proposed amendments to the local law and to the ordinance. Basically it goes in the direction of providing more information, and I can go through those, or I don't know if you want Amy to go through.
I think it would be helpful for her to go through and discuss the changes.
Mm-hmm. And then I do have some comments on them once we go through that.
Okay, great. Amy, could you take a stab at that?
Sure. Do you want me to just go through from the beginning or particular?
I think so.
Okay. Let me pull up all my notes. So as far as local law M.
Oh, actually, would it be helpful if we put that up on the screen at all for people to take a look at? Other council members, Tom, I see you nodding your head. Are you able to do that, Michelle or JR? And this would be your memo or the legislation, do you think?
I had them in the same document, so.
Okay.
All right, so that's the memo, and then the proposed amendments and legislation follow.
If you go down to page 3, I think that's where it starts. Okay, so as far as local law M, Councilmember Conti, you had in section 1, this was dealing with the appointments and the 30-day provision. In discussions with staff and the HRC, it was felt like 30 days was a short time to find appropriate people in the community to take those appointments, especially because the requirements for appointment to the HRC are fairly strict in some cases. So, we felt that adding that 30 days would make it more onerous for the board and the mayor to find qualified people. In addition, I noted in the memo that making changes to the appointment provision would, I believe, I'm pretty sure that it would fall under section 23 of the municipal home rule law and require a referendum because it's modifying the power of the mayor to make appointments. So I certainly do recognize the council's concerns as far as appointments go. And so I did add in here, that when vacancies occur during a term of membership, that the appointments would be filled by the mayor with the advice and consent of Common Council. I don't think that's really necessary to add in there because advice and consent of the Common Council is provided for in subsection 1 of that section of the city code. But to the extent that it would make the council feel more comfortable with it, I thought that that was a good compromise for the wording.
Yeah, I mean, I'm fine taking the whole section out and dealing with it separately in a different proposal, because right now the effect of it is that the HRC members serve at the pleasure of the mayor, because there's no incentive to either submit reappointments or new appointments, and that kind of takes away the council's advise and consent authority. But as I say, it's a bigger issue than HRC, and I might try to have a different proposal on it that could involve a charter amendment. Who knows? But right now, I'm going to take out that whole section on appointment, and it's not directly related to the emergency action provisions I'm trying to get at anyway.
Okay, so in section 2 of the local law, I changed the language around a little bit to make it more in line with the previous 12 subsections, just in terms of the way that they set out the Historic Resources Commission's authority and powers. I think I saw this in a similar manner to you in terms of, adding this power to the HRC so that they could make, periodic reports on historic demolitions. But I'm not sure that it needs to be quite as specific as you had the language. And the HRC had also expressed some concerns about making recommendations specifically with policies and procedures under the building code, which is not within their jurisdiction. So the way that I rephrased it makes it just a little bit more general in scope. It would allow them to do the same thing though.
It makes it general to the point that it's very general. They right now, they do review demolition, non-emergency demolition requests. So to some extent, they look at those issues now. I don't necessarily think it's outside their purview to look at or to be able to. And they're not really giving approval, or we're not suggesting that they have prior approval of emergency demolitions, because by its nature, an emergency is an emergency. But the idea was that they would be looking at after the fact demos and possibly learning from the factors that went into those demos. And some of the recommendations they're not all necessarily related to procedures. They could be related also to the factors that led to a situation where an emergency demolition was necessary, because of factors that related to the deterioration of the structure or neglect and things of that nature. So it is broader than simply looking at the policy, that you might be concerned about, but it's a broader issue. So that was partly the intent there.
I do understand what you're getting at, and I think it's a matter of policy in terms of figuring out the exact wording. To move on to section 3 of the local law.
Just Amy, going back a little bit, because the other part of it was that they would, in terms of receiving the information with regard, when an emergency action is taken, and under the separate ordinance, where they would now be getting information as to when those actions are taken, and the underlying information that, that might be related to why that action was taken. That would give them, my language gives them more authority to look at the action itself, versus the more general language that you have in terms of just making recommendations. So it fits into what's in the ordinance as far as the, I mean, I have no problem making it a little bit more general, but I think reviewing actions within districts and being able to make periodic recommendations is really what I wanted to do.
I think that there was a little bit of maybe confusion on our part in terms of you have in the language that you would propose the review of emergency actions as a standing agenda item, which seems to relate more to the specific demolitions like you're saying. But then there's also the part that talks about periodic recommendations being made based on this. So I think it would be helpful, if you want the commission to make recommendations based on, particular demolitions, or if you want them to review particular demolitions, like what does that review encompass exactly? I think that probably would go better in another section as opposed to the general powers, though.
Okay, which goes on to your next section.
Exactly, and that's somewhat why I moved it out of the unconsolidated law that you had, and had a more specific type of review procedure for the HRC. So as I understood it, this would kind of expand on that subsection 13 and include more of the particulars there, so that the
Right.
HRC would have a little bit more guidance in terms of what this review entails. So I put together this provision. I don't know if I got the numbering right, or if you guys need to change that, feel free. So I basically, the first subsection here says that they'll review demolition orders after they receive notification of any demolition order from buildings and regs under section 133-55. So that's the ordinance that goes along with this. So that effectively, as I see it, makes it, an agenda item whenever there is an emergency action for them to review, as opposed to having it just be, a standing agenda item when there may or may not be demolitions to actually look at. And then under subsection 2 here, I thought that the 180 days was maybe a little bit fast in terms of producing, this type of broader report. So I made it an annual reporting requirement. And then I tried to set out a few of the, sort of broader categories of what I thought these reports and recommendations might entail. I looked at ordinances from a number of other municipalities to try and get some of this information. I wasn't able to find any ordinance language that was really anything like what you're proposing here. So I did kind of throw this together from a few different places, but I think that it gives a bit more guidance to the HRC in terms of what this review should be looking at, and and the types of information that they would want to give to the Common Council, to the extent certainly that you think that they should be looking at different things. I would say, please feel free to add them in.
Yeah, so my proposal was just a one-time comprehensive report followed by, as they deem necessary, periodic reports. So your language would provide for an annual report that I think encompasses probably what I may have been looking for. Okay. I can play with this.
So then going to the ordinance, give me a second, let me find it here. So the ordinance relates to section 133-55, which is part of the building code.
Right.
In subsection A, the last sentence that you had added there, I wasn't entirely sure what it was adding to that subsection. In terms of it seems to just say that there's a direct hazard to health when there would be a direct hazard to health if notice had to be given. So I felt that it was just a little bit circular and kind of restated what was already said in section A.
Mm-hmm.
In subsection,
I think what you did, you took the language I had in B and just moved that to a new subsection E.
I moved it down just to have all of the new stuff at the end.
And it looks like it's the same language.
Yeah, I believe that I didn't change E at all. And then, but I did change subsection F, which is basically, so when buildings and regs provides the notification of an emergency order to the HRC, this sets out in a little bit more detail what that notification should actually include. So this is the information that would be sent to the planning board the HRC. Again, this kind of listing of particulars was based on, the discussions with HRC and staff, and then also various other ordinances from cities and towns in New York and some other places, just to try and find some of the, more relevant issues that come up with these. Again, I wasn't able to find any ordinances that do exactly what you want them to do. So it's pieced together, but I think that, this would be helpful in terms of clarifying to buildings and regs what information they need to send to HRC. And then I think that this would be, sufficient for HRC to fulfill the type of review that you want them to do.
Okay.
I would also just mention that for the most part, buildings and regs, I believe, would already be, putting this information together. Certainly, the description of the premises, the engineering report, a statement of what work is going to be done, the timetable. I think it is a bit, there is more information here than they probably put together now in terms of, I'm not sure if they include a map or a site plan. They don't provide photos, prior code violations, and information about salvageable materials. But, I talked with staff at Buildings and Regs, and they believe that, it would not be too onerous to provide this information. And then also the last few of these items, they do include the caveat that it's to the extent that such information is available, so that, especially in cases where a building really, has to come down immediately, they don't have to, run around trying to get this information before they go ahead and make sure that the property is safe.
Yeah, and I understand certain reports, like structural or engineering reports, not immediately available, but they might be available at some point. And I want to make sure that HRC would get that information, et cetera. Is there, maybe it's a question for Rick, a time frame within which information like this might be available and be able to be transmitted from your experience in terms of dealing with these issues?
Let's see, as we go through them, a lot of the stuff is pretty readily available. The engineer report is one that, we don't typically get for a few weeks out, after the fact. I'm just trying to see, photographs are usually in the engineer's report. We don't take photographs. That's, the engineer's doing that. The prior code violations, we certainly would have that, in our possession. If anything were salvageable, you know, that certainly could be, I mean, a lot of this stuff is, you know, at our fingertips or relatively easy to get. I'm just trying to see the only, yeah, I guess,
Rick, if I may,
yeah, go ahead, Val.
too, we've also recently migrated all of this data into our computer system of Energov, and we've granted Erin inquiry access so she can go in and see the records and what we have in live time.
Mhm.
Okay.
Yep.
And Val, I mean, I know when there's an emergency demo or emergency action in my ward, I right away get an email from you. I think that's simultaneous with the notice and order, not the details in terms of what the issues are, but just the notice and order, which is, I think, the boilerplate language. And I think you send that out simultaneous with with when a decision is made, correct?
That's correct. What you get is the declaration of the emergency demolition or stabilization. And that goes to a distribution list that includes Erin and includes the council member that represents the area and other interested parties. So that's just a matter of adding someone to a distribution list.
Okay. And then Aaron, I don't know if when you get one of those notices for an historic district, if you automatically just as point of information forward that to HRC members.
They can be forwarded to HRC members. And then, which is one of the items that, you know, they've requested in the past.
Mhm.
And then the list that's attached to the amendments that Amy had put through was information that the HRC had started to generate based off of the historic preservation plan.
Right. Okay. Because they can get that notice as an immediate notification followed up at a later point when available, the additional information.
Right.
that we're talking about.
And I think one of the things that we had discussed at the HRC meeting and then planning staff had discussed with Amy was having that immediate notification declaration either be distributed from the planning department to John to then be distributed, or having the chair of the HRC be added to the distribution list for the immediate notification of the declaration.
Okay. As my old boss would say, it's all in the system. It's just pressing a button. When he was waiting for information from the health department that would never materialize. Anyway. And then the other part you had is the one that deals, Amy, with the vacant building registry reports.
Mhm. I didn't change this extensively. In talking with Brad and Aaron, we suggested that, you know, to the extent that the vacant building registry, you know, is citywide and deals not just with the historic districts, but plenty of other buildings throughout the city, we thought that the planning board might like to get those reports as well.
Yep, that's fine.
And then I just, as far as the language goes, you know, throughout, where you had historic resources overlay districts, I just made that historic districts to be consistent with the city code. You know, so I took out some of that verbiage. And I believe in subsection D, I specified it a little more to include the number of historic vacant buildings by such districts. But I'm sorry, I'm looking at my red lines and trying to figure out what I did.
Yeah, I think it's the same. So it's a number of buildings
the
in
same.
category. And you have it by the individual.
Yeah, I think I just moved the wording around a little bit.
I think
Broke it up.
one thing that might not be here is just the emergency actions taken within the quarter. And I don't think you have, including number of emergency actions by historic district, both by individual, that were taken within the quarter and in the preceding quarter. because that was meant just to provide a kind of a comparison.
You're right, I'm sorry.
One other thing I noticed, by the way, I just noticed this today, I'm not sure why, maybe whatever, that cross-reference there to section 133-78.3E2.
I was confused about that.
Yeah, it's incorrect. I don't know why it was not, I didn't notice before, because it refers to tax maps. The correct cross-reference is 133-78.3, subsection H, which is the fee categories, which breaks it down by 1 to 3, 4 to whatever the different size properties.
That makes
So that, it's just to make, I'll make that correction, but that's the correct cross-reference.
Okay, anything else? Rich or Amy?
I would just note, in looking at ordinances from plenty of other places, mostly New York, I looked at a few other kind of like older Rust Belt type cities. And I think that the letter that HRC sent, in which they talked about demolition delay provisions and other options, I would suggest maybe looking at a few of those types of ordinances, which seem to be pretty popular as, dealing with this. I also saw a lot of ordinances that are specifically dealing with demolition by neglect. I'm not entirely sure how effective they are, or if they're mostly just, adding that type of provision in an attempt to convince owners not to let their buildings.
I think we tried to deal with some of those in previous years, going back a while, and I'm not sure if it was that specific, or I think also when we put some demolition provisions in for non-historic districts, we may have had some of that language, and then those provisions were all repealed and incorporated into the USDO. But actually, Brad would remember some of that discussion because he was kind of involved with it a while back.
A little bit, yeah.
Yeah, I think you were. I won't recount previous, whatever. But I would like to be able to move this forward, and then there are broader issues to look at some point, but I'd like to be able to move this out of committee with some revisions, because I think it's a start, and it's intended to try to get the HRC information involved. And I don't know, in terms of other committee members and discussion.
Yeah, other input from committee members? Does anybody else have a comment or any thoughts? Judy?
So I listened to the HRC meeting, and it seemed to me as though HRC members are specifically interested in receiving a copy of the decision at the time the decision is made. And the way this is written, it says at the earliest time possible. And I understand this is asking for more information, which then is not possible to all be transmitted. But I'm thinking that changing that provision, instead of saying at the earliest time possible, to say at the time the demolition is ordered, when such information is, and when such information is not readily available, excuse me, I'm sorry, I can't read my scribble. At the time of demolition is being ordered, unless such information is not readily available, in which case such additional information shall be transmitted to the HRC at the earliest time possible. So I think that makes it viable while making it practically viable, while also making it clear that the HRC should get any and all information at the time that is available at the time the demolition is being ordered. The other thing that I noticed which I thought was really interesting, was the conversation about the photos and making sure that there's photos of any adjoining, abutting buildings because of the potential risk to them. And now I'm hearing essentially that that information is usually part of the structural engineer report. And I'm wondering if there's any benefit to trying to make sure that the HRC is able to look at and review those kinds of photos at the time the demolition is ordered, because I think the concern is there may be a risk to nearby buildings, in which case people may want to raise questions about it before people proceed with the demolition. Not that the HRC has the authority to stop the demolition under this, but another set of eyes, other people asking questions, in my mind, is always a good thing. So that was the other aspect of this that I'd love to get HRC members' thoughts on. And Richards, anybody else?
John, do you have any thoughts on that?
Yeah, I think there has been a lot of discussion about photographs, and it's largely centers around the context of the building being lost and having some last snapshot and record so that we know what was there, and it can guide some decision-making on replacement options for that particular site, if it's retained as an individual building site, or if it's amalgamated into something larger. But I know Jack McEnany has always been, very vocal about the idea of getting photographs and having a real understanding of what the loss is. Again, the HRC has no intention of standing in the way of a true emergency. It's really gathering the information, and I think getting notification to Aaron and myself when it's issued, that a demolition is about to take place or an order has been placed, and then the information follows at a later date, so that we put that into the collective knowledge and use that information to guide, I think, processes going forward. And that's your intent with using this as kind of a lessons learned, and how do we alter the landscape, so to speak, in going forward with preserving as much of the built environment as we can.
Judy?
Judy, you're mute.
The other thing that I'm interested in hearing a little bit more about is Amy mentioned that there are provisions in other municipalities for the potential delay of a demolition. And she mentioned that we may want to take a look at that. And I don't necessarily think it should hold this up, but as long as it's fresh in my mind, and it's fresh in Amy's mind, having done the research, if she could expand a little bit on what exists that in other municipalities that she thinks that HRC may want to take a look at, the council might want to take a look at in terms of recommendations for future action.
I think Aaron might actually be a little bit more familiar with demolition delay ordinances than I am. I didn't read them too carefully since I wasn't looking for them necessarily, but I would be happy to to put together a couple of them from other municipalities in New York and other similar type municipalities. I know I saw quite a few in New Jersey and Massachusetts.
That would be great. And send it over to us, to Michelle or
Sure.
If I can add, even more so, I'm interested in the HRC taking a look at some of those provisions and figuring out if there's something in particular that you think would be beneficial to be within your authority. Thank you.
Okay.
Any other comments? Erin, I see your hand.
Judy, I can send some examples as well. The HRC does have built into their demolition requirements that, and a lot of demolition delays work this way, is that it allows time for buildings to be documented, as well as look for alternatives to demolition. So whether there's other property owners or alternatives can be found for the property. But I'll work with Amy and we can pull some examples.
Thank you. Any other comments? Brad?
Yeah, I just wanted to add, I think that, all non-emergency demolitions are either referred to the HRC or to the planning board if they're outside a historic district. So I think those entities do have sort of a de facto authority to delay the demolition based upon circumstances, but it might make sense to look at those existing ordinances and see if that needs to be called out more specifically. I know that there's been some, discussion of the planning board demolition provision. It's really looking at the site plan and what's going to replace it. And I think there's a little bit of an open question of how much authority they have to deny a demolition outright. So that might need to be something that's clarified.
Okay. Unless there are other comments, I was going to suggest that Amy, you and Richard work together to make some revisions, have some conversation about some of the changes that have been discussed, and then we can bring this back.
I think that we're basically on the same page, and I can take this and amend my proposals to incorporate this. There's some tweaking or whatever, but I think basically, if we can move it out, and I'd like to be able to turn it around for our meeting on Thursday. I don't plan to pass on Thursday simply because the local law has to age. But I want to be ready to have it amended on Thursday and then pass it as a package at our meeting in March. But I think I can turn some language around for Amy on this, and then I think we're basically in the same area. Judy has her hand up still. I'm not sure if that's a leftover or if it's more.
So yes, I think we have to move these out separately, but I would like to go ahead and make a motion first with regard to local law M of 2020 to move it out of committee with a positive recommendation with the elimination of the provisions in section 1 and substantially the modifications I think that were put forward by Ms. Levine, however, with some reworking of what provisions go where with regard to what Mr. Conti is looking to achieve. I think that there is agreement on essentially the substance of that, and it's just a matter of leaving it to them to work out the language differences. So that's my motion. I'd love a second.
Second.
Okay, any discussion? Okay, all in favor?
Aye.
All right, moving it out with positive recommendation. And this was local, was this the ordinance or local law?
This was local law.
Okay,
local law M, but I would like to make a similar kind of motion with regard to ordinance 21.92.20. That also be moved out of committee, consistent with the amendments that have been discussed and agreed to. And I note that there have been some changes to the provisions of 133-55 to move some of the provisions into subparagraph E, some modification of the provisions that were in E to make it subdivision F with further details, and I really appreciate those details. I would like it to reflect the fact that rather than being at the earliest time possible, that the Historic Resources Commission will receive the notice at the time the demolition is being ordered, unless such information is not readily available, in which case it should be made available to and transmitted to the HRC at the earliest time possible. And then also noting that the quarterly reports, there's been some minor modifications there, including transferring, also putting the planning board on notice, making a change to the category set forth in subdivision D, and noticing that there are, that the reports will include the similar information for the preceding quarter so that there can be a comparison made. There may be minor other differences, but I think that that substantially takes into consideration the modifications that we're looking to have made, and leaving it to Richard and Amy to work out the language and let us know if there's any sticking points then that need to come back to us. That's my motion, moving it out with a positive recommendation in those amendments.
Second.
Okay, any discussion?
And just to clarify, I think when Judy, when we refer to the notice at the time the order is made, I'm thinking that that notice is the notice that Val currently sends out, which is the notice and which I guess Aaron gets, and then we're just providing that's the notice, and then it's followed up with the more detailed information.
Well, I agree. However, I am thinking that it's quite possible that some of the information that is listed, it might be possible for that to be transmitted at the same time. And that might be further informative to people as they're looking at the notice. Sometimes those notices of demolition don't give you a lot of information about what's really going on. So again, to the extent the information is available, if there can be additional attachments to that email, providing that notice that contains some of that additional information, that's my intent, but it is not, it's not being detailed which is going to be available at which time, so we have to leave it to staff to make those determinations. I'm just making it clear what I think would be beneficial.
Yeah, and again, I don't think the information that's actually available beyond is going to be beyond the notice that Val sends, and the more detailed information is not going to be available, because I think, and Rick can point, because a lot of that is observation, determination, discussion on site, and things of that nature before actual written material is put together.
Correct. And not to mention, some of the people on that initial list for the notice are not the people that are going to need this additional information. So that initial one has to go out immediately in order, for some other things with Department of Labor and waivers and things like that. So as long as we have the provision, if the information is available, but I can almost assure you it'll almost never be available.
Okay. So we'll include Judy's language basically, but that's whatever.
That's the understanding. Okay. Anyone else? All right, all in favor?
Aye.
Okay. The ordinance passes out with a positive recommendation.
Okay, so I'm going to take this, I'll work on tomorrow, get some revised copy to Amy with the intent that we'll have this ready to amend at our meeting on Thursday. As I said, the local law has to age, and so my intent would be to try to amend it at Thursday's meeting and have it ready then in final form for passage at our March 1st meeting. But I'm going to hold both pieces so that we can move them at the same time.
Okay. All right, thank you, everyone.
Thank you.
So now we'll move on to the technical change ordinance, the USDO. So there was a lot of emails back and forth, Brad, and with Judy, and concerns about the dates that were on the documents from general code. So maybe we can talk about that briefly and see if there are any additional concerns about moving this document forward for passage.
Sure. Did you want me to address that, Kathy?
If you could, yeah.
Yeah, so, I was able to review the most recent document sent by General Code. I did confirm that, per my reading, all of the items that we had put together, I think Judy had provided a list of comments and some others from other members that I then incorporated into a Word document and forward that along, as well as attaching the ordinance that have been passed since the original code was adopted. So far as my review can tell, those were all included in this most recent version. And with respect to the date, in following up with general code, they indicated that that's a manual change that needs to be made with respect to the footnote on the date. Why that went from September 19 to 6/1/17 wasn't entirely clear to me, but they did update it to state the publication of February 2021, which would be consistent with where we are now. And nothing, I did sort of a broad review, nothing jumped out at me as being missing or clearly deviating from anything that we had reviewed prior. So my belief is that it is consistent with the 2017 code as amended per the 4 or 5 council ordinances, as well as the comments out of the prior 2 or 3 discussions of this committee.
And does any committee members want to comment on this at all? Judy?
Well, first of all, I'm wondering if JR has had a chance to review this. My concern is we were given a 350-page document printed out that was dated September 2019. I spent over 40 hours reviewing over 300 pages of that in detail, and found, and we were told that there were no content changes in that particular document. So after having found 1 or 2 content changes, I then felt the need to do this detailed review of the September 2019 document. I expected that the September 2019 document would then be what is been amended. And my concern is that possibly somebody at Gen Code was given our list of changes and they inputted it into a prior document that was dated June 1, 2017, which then my review of the September 2019 document is somewhat irrelevant. Because who knows what additional other differences there are between the June 1, 2017 document and the September 2019 document. And I don't think we have a clear answer from Gen Code as to why, if this date is manually inputted, why it was sitting there. And the obvious answer is, just like we got all these prior documents that were actually from 2020 that were dated September 2019, this one from June 1 of 2017 is a prior version of it that we have not reviewed, that they then made changes to. That's, you know, if we had not gotten a document for which the redlining was not accurate, and then we were told that there were no content changes, and there indeed were differences in the content and other things that were missed, I would not have a concern. But I gotta tell you, having spent 40 hours doing that kind of detailed review on a September 2019 document, kind of churns my stomach that I'm now being presented with something that indeed had a June 1, 2017 date on it. And one of the reasons why I'm asking JR if he's had an opportunity to do a review of it is, you know, has anybody done a detailed review to make sure that what we're now being given is essentially the same as the document we were given to review a month ago or 2 months ago?
JR, did you have a chance to review?
The only thing, the most recent document that came out with the dates, the date changes that I reviewed, I looked at them briefly and just looked at them to see if they had the most up-to-date amendments to it. And none of them had like the blood plasma or the HOE amendments in there. Only one of them that I believe Brad sent a while back, a little bit before these dated change on them, they had it, but I couldn't tell if they had the other changes that were also made.
JR, did you receive the February 15th, 2021 copy? Is that the one you reviewed?
That's the one that I reviewed also, but that's the only one that I saw that had the most, that had some of the up-to-dates, but I didn't see all of them, because then when I got the subsequent the subsequent PDFs, that's when I got confused.
Okay, because I went through that one and checked all of the comments that we had presented them individually, and they were all in the document, as well as the ordinances that have been passed since the adoption. So that was my review, but you know,
because I did ask if that was which copy it was, and if you're saying that's the one, then I'll review that one more in detail, because I couldn't tell with three of them, three PDFs with 300 pages each. I couldn't do it just would not have been possible to do a detailed which one was correct.
Yeah, I mean, we're in an unfortunate situation where we're 3.5 years past where a code was adopted. Several versions have been floated around and transmitting, and I think we're doing the best that we can to align this with the current state of where we are. And again, it appears to me that the date change was merely a mistake. There weren't content changes associated with that, but can I definitively say I went line by line and read through? No, I can't. I mean, that would be a significant task. That's what we need to do. That's what we'll do. But you know, I do have confidence that, you know, this version incorporates all the changes and is consistent with the adopted version, which was 6/1/17. So, you know, I think to the extent that that date was being utilized, you know, that is the original adopted code date. So, you know, that would seem to me to be an accurate representation of the original adopted code, amended for the edits that we have all discussed in the past 2 or 3 committee meetings.
Any other comments? Judy.
So the problem is not that whether or not it contains the 4 pages of particular amendments that we've now asked for. The question is, what about the whole rest of the document that could be a June 2017 document instead of the September 2019 document that we reviewed? So there could be things that were left out that were picked up later in it. I simply don't understand. If I got a document that was dated at the bottom, September 2019, whether it had one numbering of tables or another numbering of tables doesn't matter so much to me, then I would feel comfortable just focusing on what we then had decided needed to be added as amendments. I don't know what this other document is. I never reviewed that other document.
I'm happy to take whatever guidance and course the council would like to proceed. So just let me know how you'd like to proceed and I'll move in that direction.
Well, I mean, one of the things that Brad has said, Judy, is that anything that he submitted to general code has been updated all along. And that the date, I mean, they're saying that the date at the bottom is separate from that. So if things have been submitted to general code all along, then you would have all those changes that that we've been discussing.
I don't think he said that. I think he said that there are a number of different versions of the USDO that have been floating around, and they are doing the best that they can.
But have you said that in the past, Brad, that when you've submitted changes to the general code, they're constantly updating, so they're not going back to the original version, are they? Ever?
I think that whether the document that we had distributed for review said September 2019 or June 1st, 2017, they're both supposed to be the original June 1st, 2017 adopted version. I think the fact that one said September 2019 was probably the mistake, if anything, that should have originally read June 1st, 2017. Again, we had gone down the road of making changes to the document in addition to the copy edit changes in the hopes that we could codify the content changes and the copy edit all at once. That's where I think the September 19th, 2019 version is derived from. Again, I think all those content changes were removed. I think when we did the diligent review of that document, we went through and caught a few things that were remaining in there that we then took out or asked general code to take out as a part of these changes. So again, I don't think there's any difference between the documents apart from the naming at the bottom, as well as, we discussed there were a number of tables that were requested to be renumbered in October, November of last year that are also present in the February 2021 version that I provided to the council yesterday. But apart from that, I think we caught everything.
Okay. Any other committee members would like to comment on this that haven't commented?
Hello?
I'd like to know what other committee members think.
I believe
about whether we
Councilmember
should move
O'Ballerin
forward or.
and Councilmember Doche had her hand up too.
Okay, I'm gonna go to Alfredo first, and then Judy will go back to you.
I kind of agree with Judy's sentiment. And I have frustration after spending X amount of time on a very large document, going by line to try to cache anything that was, an error, and now not knowing if that's the document that we're going to be asked to vote on. I understand the frustration. I get that 100%, and I'm trying to figure out how can, I don't know if there's any other way than to go through this new document to feel comfortable that it is the same document we already went over before. And I haven't gone through the new document. But I don't know what else. I don't know what other way to make sure that we, are voting on the actual document that we reviewed and the actual document that we spent a lot of time on, making sure that we cross-referenced from the original document to make sure that if there were any changes, we spoke about it, addressed it, and moved on. So I'm not sure if there's another solution. I'm hoping maybe someone has another solution that I'm not aware of, but I don't know if I feel 100% comfortable voting on something that we don't know if it's the same document we already reviewed. And I know it's a huge chunk of a document, but I 100% understand why Judy's so frustrated. Because so am I. It was a lot of work and a lot of time, and Judy surpassed, and we appreciate that so much. But I know a lot of other people spend a lot of time as well, so I get it.
Okay, thank you, Alfredo. Judy.
Thank you. So here's part of my frustration is Brad just said the document that is dated 6/1/2017 is the document as we adopted it, which makes sense because we adopted it on May 15th, 2017. That's what we adopted. But we got a different document back in December, a different document that had a lot of edits in it. It wasn't just the table renumbering. There were a lot of other minor edits in that particular document. And there were some more substantive edits in that document. But it wasn't just what we adopted. So there are places where, they picked up, the word and needs to be and, A-N-D. There are places where there were, some words dropped. There were all sorts of little minor changes, which if you were looking at the red line version, while you're also looking at the old version and also looking at the September 19th version, you might pick up on a lot more of those distinctions, those minor changes. So what was the point? If we're now going to go back and just adopt the June 1, 2017 with only the changes that we agreed that should be made to the September 2019 document, I don't know why we went through that effort.
So what, Judy, I don't understand, I think we need to come up with some kind of a pathway. I'm not clear on what documents we should be comparing now.
Well, right, which is the point I made during the exchanges of emails when I said, JR is asking which documents should he review, and I don't have an answer because frankly, I don't think we have it in-house. So one choice is to ask staff in, the planning staff and also JR to go through both documents, the September 2019, along with the edits, and the edits are a little less important now because most of those edits have been picked up, or all of those edits have been picked up. I have a question about the blood plasma issue, but as between those, as between the revised document that we got that was dated June 1st, 2017, and what we got, either one of the ones that are dated September 2019, so either somebody needs to go through and figure out if The new version now has all, is word for word otherwise consistent aside from what we now added to it. The other thing is, and I think that I would have preferred for us to do this as soon as I noticed that date difference, is to simply go back to Gen Code and say, now you gave us, you need to take the document we reviewed and you need to input the changes that we asked for in it. That's a little frustrating because they have picked up those changes in this document that we now have. It's just, I don't know what else is different in the rest of the document that we didn't ask for changes on. So that would, I mean,
Is that a possibility, Brad, to go back to Gen Code to make that request?
Well, I mean, again, Jim's code explanation was to me is that, you know, they changed the date on it to the wrong date. And unfortunately, because of that, we've lost the confidence of the committee here. So, you know, if what I have to do is go through and compare, yes, we'll do what we have to do. But I mean, that, I don't know when turning that around, and I mean, we'll try and do a compare, but it's a PDF. I don't know how that'll work. Try and export it to Word and do it that way. Yeah, again, I think general code merely changed the date at the bottom to January 2017 instead of February 2021, but I can't, you know, I didn't edit the document personally. I didn't look over their shoulder while they edit it, so I don't know that. So I'll leave it at that.
Okay, any other comments by any other council members?
Tom has his hand up.
I'm sorry, Tom, go ahead.
Yeah. A couple of things. I just want to understand the changes that we've made since June of 2017. So I can think of my ordinance, my change to the USDO, the blood plasma. Are they included in this version that we're going to vote on?
Yes.
Okay. And okay, if they're there. So I'm just confused, Judy. Are we missing stuff or we're just not sure because of the date?
I have a significant level of discomfort that they made the changes that we asked for to a document that was in existence on June 1, 2017, as opposed to the one that they made that we all reviewed in detail. Do I know that? No, I don't know it any more than Brad knows what happened here with it, and it's unfortunate that we're in this situation.
I wanted to find out, is there a way that we could have Gen Code, a representative from Gen Code, meet with the committee that we could kind of, this is an the USDO is part of the legislative stuff that the council is responsible for. Is there any way we could talk, have somebody there that we could pick their brain, Brad? Is that something that you think we might be able to do?
I can ask. I will say that, we've expended the budgeted amount for this project, and I had to, well, all of your edits were helpful in getting them to, provide all the changes that we asked for. And so far as I know, they haven't charged us for any of those, but, we were sort of at the end of our rope with them, but I will be happy to ask that question, being that, again, they have sort of inserted confusion into the process once again, and I'll inquire more. I inquired via email and I received the response. I read it, I think on yesterday. So, I transmitted the new document and the response, the explanation to the council as soon as I got it. Unfortunately, it was just a day before this meeting, so I didn't have a chance to have a larger conversation with them, but I can certainly try and do that. I mean, you know, again, I don't know why they would have gone back to an older version of the document to make these edits to, but particularly since it has the table numbering changes that were made between. In any case, you know, clearly I don't have the confidence of the committee here, so we'll follow up with general code and see what we can do.
Thank you.
Okay, so Brad, I guess you'll be back in touch with us on that. And then we'll have to schedule another meeting or make a decision as far as comparing documents. And JR, if you can help us with that, if we need to do that. So if you could let us know, Brad.
I will, and I say this reluctantly, but I may be reaching out to the council to you know, request an extension of the time to deliver the 6-month changes to you. You know, just due to the amount of time it's taken to go through this process. And again, you know, it's not, yeah, I bear some of the responsibility for that. So I'm not, you know, trying to do this, but, you know, it's going to take some more time to go over this, and we're rapidly approaching that March 1st date. So, you know, I think if it's more April 1st, that would be something that I do plan to request.
April 1st for?
To deliver the larger package of you know, USDO changes. I do still plan to get the data of all the statistics for the projects that we've reviewed to the council for the March 3rd date.
Oh,
but,
okay.
But you know, between that and following up on this, I think over the next couple of weeks, you know, gonna have a full plate. So
okay, that makes sense to me. Tom?
Yeah, I just wanted to find out, Kathy. You know, I heard Brad say that, you know, about the money that, you know, maybe we used up all the money and stuff. This is such an important document, the USDO. I know I'd be willing to give more funding, you know, to vote on more funding. I don't know where we would get the money, but I'm just asking you, is that something we could, you know, think about? Or, you know, like I said, this is such an important document. To throw a little bit more money so we're not rushing and doing something that we're not sure of. I would be in favor of voting to give them more money, but I don't know how everybody else in the committee feels.
Well,
I don't think it's a money issue on our, I think it's just a time issue. If we need to spend a little bit of money to get this done, we're happy to do that in the most expeditious way, but I do appreciate the support.
Judy?
So I'm a little nervous about something here, and that is with the delay by another month. And Mr. Glass, you've said you bear some of the responsibility for that. I earlier today was listening to an HRC meeting in which a member of the administration said that the council has unnecessarily dragged its feet on another matter. And I have, on a matter regarding approval of planning board members that we did within 33 days when we were given 45 days. But, and with regard to one planning board member for which we received the appointment letter a full year after we should have received the appointment letter. I'm just wondering if now this gets reported back to the administration that we are causing delays in the adoption of these changes. If we, the council, are responsible for these changes because we didn't get the printed version for a month, we immediately reviewed that. We immediately had meetings on it. We shared information on it. And then what we've gotten back is something with you know, different dates. And then there's been some confusion about tables. I don't see the Common Council having any responsibility for having legitimate concerns over what is being presented with us when there are date changes to the document. But I'm wondering if that is what is going to be reported back to the administration.
Are you asking that question to me, Judy?
I am.
No, I don't believe the council was the cause of delay. I think we've had a very constructive dialogue. I think, particularly with respect to the prior version, there were in fact some errors. And again, I think that it took a significant time. Unfortunately, we would have loved to have it codified when it was originally passed. There wasn't the funding to do it at that point. So I don't think we bear responsibility for that, but this has been a long time coming. So, I do understand the, I understand the concern. Unfortunately, general code hasn't served us perfectly as well. The number of times they've surprised us by posting the code online or, making certain edits to the document or not making certain edits to the document. So, I think it's just like you've said a number of times, it's a 350-page document. Anything related to it, and particularly looking at it holistically, is a challenge. I think we're always going to point fingers at each other to some degree, fairly or unfairly. But my intent here, no, is not to cast blame on the council for this. I think we're happy to be here working together and making sure that we get it right. I'm looking forward to get this codified. I know that never want to see this happen again. That something takes this long to get codified, because we see what happens. I mean, once you get versions out there, no one really knows what the real thing is. So I'm going to stop talking now, but I hope I answered your question.
Well, I just want to say I appreciate that very much, Brad. And I just, I have worked my butt off to review the document in 2.5 weeks, a 350-page document in detail, try to provide, communicate. I think essentially what I'm trying to say is I am ready, willing, and able to do whatever it takes to keep us moving forward on this. My problem at this point is, having just spent 40 hours going over it, line by line, I don't consider that an option because of this. And I whatever you can do to give us more confidence in that, I will appreciate.
Yeah,
thank you.
I'm confident we're going to look at it, and it's going to be the same document that we all think it's supposed to be, and we can all come back here and finish it off. So
Good.
Thanks.
Thank you.
All right, and Alfredo, go ahead. Then we can wrap up.
So my question is this: if this new document that's getting cleaned up is going to be the document that you're going to be presenting to us, or similar to the document that you're going to be presenting to us, why do we have to push back that date? Part of cleaning this document up is preparing for the final document that you're going to send us in March. I just don't like keep pushing back dates on something that's already been pushed back 3 years. And again, there is a deadline that is fast looming. Where we're going to lose 5 to 7 members that voted on this, that are still here. So I have some hesitations with us just keep moving the date back on a document that, if the document that we're going to be asked to vote on is the same document that we've been reviewing for the last few weeks, then that should also be the same document, or a very similar document, that's going to have all of the more substantive changes. So I don't understand why that pushes it back a whole month, when, if anything, we're only pushing this possibly back 2 weeks. So now I just, if we would have passed this today, that would have given us 14 days from roughly 12 days, 12, 13 days from the 1st. So if we pass this on the 1st, why can't we say it'll be ready for the 15th?
Alfredo, another concern that I have, and I will directly address your question, but another concern that I have is I would like for this to be online, when we're going through the code, and that requires the council to pass it. So I think having this document codified and all accessing the same document through general code will be helpful in conducting our review. But I think what we're talking about, is I do have to go line by line through the document. I'm confident it's the same document we're reviewing, but that does take time to go that level of detailed review. That said, that's going to cut into other time to work on other things. And
Alfredo?
I mean, I definitely understand the time commitment when you go line by line. I think that's why Judy's so frustrated. I think that's why I'm so frustrated. I think that's why so many of other members are frustrated, because we understand how much, because we've done it. I just have a problem with us keep pushing the date back, Brad. I have to be honest, and my concern is, okay, so now we're gonna say April, and then something else is gonna happen, or it's gonna take more time to get something else approved, and then we keep pushing it back to May, and then something else comes up. I mean, I just feel like if you already know what the changes are, then let us know what you see as the changes that are going to be, so we can start talking about them. If we know there's going to be some controversial changes, let's have those discussions now, so that when we actually have the final document to vote on, a lot of the back and forth has been settled.
I think what we'd like to do to some degree is let the actual case statistics and the cases that we've reviewed and are familiar with guide us in making changes. So I do believe, provided that we are going to be going through those as soon as March 2nd, that will provide an opportunity to raise a lot of those issues you're referencing. It is fair in some cases to say that the changes are already done and that we did bring a package to the planning board earlier last year. Happy to provide that to you, but I think we are going to take a closer look at that to make sure that we're tailoring it as best we can to what the intent of the code review was, which was to look at what we've learned from applying the code and any inconsistencies, omissions, or errors that we found. And I think to some degree, I'd also like to, rather than present specific detailed text changes, leave it a little bit more open-ended so that we can discuss the issues and conclude upon the appropriate means of pursuing and some of that language, as opposed to me delivering you all the preconceived, solutions and expecting you to necessarily endorse those. So, again, I think the conversation is still going to start on March 2nd, and I think that I think it'll help us get some issues out on the table and have some initial dialogue as to how we can proceed with those. So I guess I'll say I'll leave it at that, and I'll ask for the council's consideration in a more detailed product to come sometime thereafter.
Okay, unless there's anything else, I think we should adjourn for tonight, and we'll look forward to hearing from you some more on this, Brad. Okay. All right, a motion to adjourn.
So moved.
Second. All right, thank you very much, everyone. Good night.
Good night, everybody.
Good night, everybody. Stay safe.